That's like the charity.
Please do. Please do.
I'm outside. How are you?
Oh, sorry. Testing? Yes.
Good evening, folks. Maybe I could bring our meeting to order. As you know, this is the second event that Torys have come to and helping to provide some of their expertise. And in a moment, I'd like to introduce our keynote speakers for this evening. I'm not from this part of the campus, although I am in the Faculty of Engineering, so let me quickly introduce myself. I'm Howard Armitage, the founder of the Conrad Business Entrepreneurship and Technology Center. I recognize a few of you who are going to be coming into our master's program in the Accelerator Center next year, and I think, Blake, I even see you in the background, one of our current students here. This is a particularly important topic for our students in entrepreneurship because so many folks come in with great ideas, and one of the things that they need to pick up along the way are the business skills to move those ideas to fruition, not the least of which is the importance of intellectual property, intellectual policy type of contracts. So tonight we have Torys with us again. And as many of you may know, this is one of the largest and most prestigious legal firms in the country. If you are following some of the news, you may know that in some of the top deals that have taken place in Canada, you will see the Torys name represented. A great example of that has been the IPO of Hydro One that Torys were very much part of. Some of you might know the name Talisman, Talisman Energy, and its acquisition by Repasol. And another example might be the Cadillac Fairview and First Capital Realty in Target Corporation's CCA proceedings. Very well-known firm and brings to us a great degree of expertise in what they do. Let me introduce our two speakers tonight for you, and I'll begin with Yolande Dufresne, if I could. Yolande is an intellectual property and regulatory lawyer at Torys. In addition to being a lawyer, and I want you to listen to this, she's a Waterloo alumni, holds a degree in system design engineering. So. Yolande, since graduation, advises on intellectual property and related transactions, including the acquisition, enforcement, and exploitation of patents, trademarks, copyrights, and industrial designs. And believe me, as some of our own students in the MBET program go through their development, how important it is that they understand these particular topics. Yolande has significant expertise in advising on risk management in intellectual property and regulatory matters. She regularly advises clients in the regulated product industry, such as medical devices, and on issues such as privacy, access, and information, and anti-spam. So welcome, Yolande. Looking forward to your presentation. Our second speaker, perhaps the first speaker, but I wanted to introduce Yolande first because of the
Tory speaker, yes.
Edward Fenn, welcome Edward, is a partner in the intellectual property group at Torys. His practice focuses on patents, trademarks, trade secrets, licensing, and technology transfers. He advises clients on patent procurement, portfolio management, and negotiates agreements on the use and transfer of intellectual property. Ed is also a registered patent agent in Canada and the United States and a trademark agent in Canada. Please help me to welcome both our speakers, Yolanda and Ben, tonight, and thank you very much.
Thank you. Howard, thank you so much for your kind introduction. Thank you so much. So, welcome everybody, and first of all, a big thank you to the University of Waterloo Engineering School for having us here again on this part 2 of the Startup Law series that Torys is working on and co-sponsoring with the University of Waterloo. Yolanda and I are here on the second evening to speak to you about IP law. For those of you who were here 2 weeks ago or have watched the web stream, in our first presentation here, we have discussed with you the concepts of corporate law and the importance of proper structuring of corporate organizations, shareholder agreements, as well as agreements as between founders and investors to preserve your equity and your capital in your startup. We're going to change gears a little bit tonight. Yolanda and I are going to talk to you about IP, intellectual property. What is intellectual property? How relevant is that to a startup? And the way we're going to try to address that is to go through a number of case studies. We're going to talk to you first about the Death Star, because that's a topic near and dear to my heart. Yolanda is then going to talk to you about the social network. If time permits, we're going to talk about the kernel. And then I want to take you through just a case study on patents in the world of IPOs through Twitter and Alibaba. And then I want to just show you the types of inventions, patentable and otherwise, that comes out of an environment like this, a startup community where everyone has new ideas that they can bring to the market. At the end of the first hour we have with you, we're going to break up into small groups, and I think, judging from this, we're going to do 2 groups, one at the back of the room and one at the front. We're going to split up along with our colleagues who are here tonight. We'll take your questions in a slightly smaller group setting, and then afterwards there's dessert and coffee outside. We'll linger outside too and chat with you all some more. So quickly, just to point out, and Howard's very gracious and talk to you a little about the work we do. I think I would be remiss, since we are here in Waterloo, if I don't also point out that we have with us David Chaikoff, our partner and leader of the Torys Tech practice, who also serves as lead Canadian counsel to BlackBerry. So welcome and thank you, David. Also my colleagues, by the way.
Go out and buy the Priv.
Go buy the Priv.
Great Android BlackBerry phone.
You will recognize my Torys colleagues by the people wearing name tags today. I have with me Steve Hundle, Tasha Defrahitas, as well as Vanessa Komarnecki, that's joining Yolanda and me today. So we're going to have some fun. I think I'm looking at Yolanda, and I think she's going to nod when I say this. We don't really need to hold questions to the end. Something's on your mind. We say something that doesn't resonate fully with you. Put up your hand. We'll talk about it. We'll try to repeat the question for the benefit of those on the web stream, and then we can just talk about issues as they come up.
Good.
So I am going to start with the Death Star. I hope this is something that will be a relatively simple example to go with. And I'm going to use the Death Star to talk about what I suspect is the most discussed form of intellectual property, patents. I'm going to talk about patentability and the Death Star. So, basic facts. I am going to leave reality for a bit and go to a galaxy far, far away. But I am going to use the reality timeline. 1970s, the Death Star was conceived. Who conceived it? George Lucas or somebody in the Imperial Corps? Let's not discuss that too much. Death Star was conceived. It was done on a napkin in the back of a restaurant. Imperial engineer decided, you know what? Those pesky rebels, I need to deal with them. I'm going to deal with them by a Death Star. Drew the first sketch you see here. On the back of a napkin, Death Star. Engineer goes back to work the next day and says to a supervisor, yeah, you know what? I've got the perfect tool to wipe out those rebels. The manager says, yes, that's great. I think that's a wonderful idea. Commissions a team to prepare detailed plans on the creation of a Death Star, resulting in our second drawing. They even build a prototype. We're going to test this out. We're going to build this Death Star. So, in this alternate universe, I'm going to start with the basic question of, is there an invention? Is the Death Star patentable? To be patentable, you have to meet a number of basic criteria. Those criteria are, is it novel, new, never been seen before, never been done before? Is the innovation non-obvious? It's new, but is it sufficiently different than what's been done before so that it is non-obvious? Thirdly, it has to have utility. Is it useful? So, in my alternate universe, you've had Imperial Star Destroyers, you have X-Wing fighters, you have TIE fighters. Engineer comes by and says, I want Death Star. I'm creating Death Star. Start with a softball question. Is that new? Please, somebody, anybody? Yeah, new, right? There has never been planet-sized battle station built before to wipe out another planet. New. Is it non-obvious? I'm actually going to park that and come back to it. I'm going to go to utility first. Is it useful? Yes, very clearly so. We all hear about IBM, BlackBerry, pharmaceutical companies as big patent filers, big patent holders in the global patent arms race. Military technology is actually right up there. Now, many military technologies are actually not patented, and that's because of government secrecy policies, but many innovations come from the military space. So we have, it is new, battle stations never seen before. We have useful, non-obvious. That's always a bit of a tricky question. Non-obviousness asks, you've come up with a great new invention, you want to put it out onto the marketplace as a product. Is it sufficiently different than what's out in the marketplace? So if you're in my alternate universe, you're saying, I have X-Wing fighters, I have Star Destroyers, Star Cruisers, TIE fighters, freighter crates. Is the creation of a Death Star non-obvious based on what is known? What is the current state of the art? The state of the art of military technology in this alternate universe at that moment, I would argue, does not encompass a planet-sized battle station. Any thoughts on that? No? Good? Good. So, if you were the Imperial engineer, you might be asking your manager, should we get a patent on this? Now, what are patents? So I've just told you what you need to get a patent, but what are patents? Patents are legal instruments. They are granted by different governments, so it's jurisdictional based. If you say you want a patent, you actually then, the first question you'll get from the patent lawyer is, in what country? United States patent, Canadian patent, European patent, Chinese patent. Here, galactic patent, or whatever planet you're on that has the planetary government. So you would say, the engineer would tell the manager, should we get a patent for this? I think this new idea I have is great. New, absolutely useful, non-obvious. We should be able to get a patent for it. Patents require the act of inventorship. For someone to say, I have a patent, you have to also say, I invented it. What does that mean? That means the manager of the engineer that came up with the idea on the napkin, Death Star, can't really say he was the inventor, because he or she really just asked a team of people to draw up the plans for it. What's worth thinking about in that scenario, though, is there one inventor, the inventor who sat in the back of a bar and drew on the napkin the Death Star? Or is the inventor a team, an inventor's team? All those people that drew up the detailed plans for the Death Star. I don't think we're going to answer that question in the time we have. I'll just give you the conceptual thinking behind that. The concepts under patent law here are so-called conception, which is the coming up with the spark of inspiration that leads to a patentable invention, the back of a napkin, and the so-called reduction to practice, which has to do with the detailed work that goes into turning an initial idea into reality. What are the work that's needed to draw up the detailed plans, building a prototype? That's called reduction to practice. In most countries in the world, it is the act of conception rather than the act of reduction to practice that leads to inventorship. What does this mean for our Imperial Engineers Corps? It means the person that sat at the back of the bar and wrote on the napkin this Death Star drawing would be considered the inventor. And the people that worked on drawing up the detailed plans for putting that into place likely will be considered the team that reduced that idea into practice and would not be named as inventor to that patent. I'm going to jump past an issue which is perhaps looming large in your mind as to, well, that's great, but they all work for the empire, so what does that really mean? I'm going to leave that question for Yolanda to answer when she talks to you about the social network. I'm going to stick with the concept of patentability. Jumping between timelines and alternate universes. So the empire decided not to file a patent right away. They said, you know what, we're going to build this thing, we're going to test it, see how it goes. So 1977, in our universe, Star Wars was published, A New Hope. The Death Star was test-fired. And I would argue that it was test-fired in a very, very public way. There is a planet out there which feels that very much. So the empire didn't file for a patent, the inventor didn't file for a patent, manager didn't file for a patent. They go out and build the Death Star. It's in plain view. If you're flying by in your Star Cruiser, you will see it. And they also test-fired it. The way that to some very, very interesting effect. Well, now that the cat's out of the bag, so to speak, in the world of patent law, back to our universe, that would be considered an act of publication. How is publication relevant to your startups? Well, testing in public, publishing a paper on the internet, talking to all your friends without a non-disclosure agreement. Those are all acts of publication. And what publication does is it starts a clock on your patent application process. In North America, you have 1 year from your first act of publication by you, not by someone unrelated to the inventor, to file a patent application. In the rest of the world, outside North America, there is no grace period. If you publish today, you will not be able to file for a patent in Europe tomorrow. So, if you were interested in obtaining a patent for your Death Star, one of the keys is to make sure you file your patent application before your first publication, before you build it and show it to the public, before you shop the plans around to investors. Those are all important things to do. Or if you must talk to somebody, if the Death Star was developed by an imperial engineer who decided not to tell his manager about. He wants to do a startup. He wants to start up a company to build military weapons, star-based weapon systems. He needed funding. He needed investors. Think about either filing a provisional application first to protect your right for patenting, or make sure you have good NDAs in place as you're talking to people, so that you do not have an act of publication which destroys your ability to obtain patents moving forward. So that's the Death Star. So a few years passed.
Ed, we have a question.
Oh, yes, question.
Does the NDA protect you from publication? I mean, if you have an NDA with an employee and he publishes without consulting with you, are you protected? Is your patent protected in Europe?
Yeah. It's an excellent question. The question was, does an NDA protect you from publication? The answer is not really. So the question was asked, the second part to the question was, if you had an NDA with a counterparty, and they, despite the NDA, publishes it, does that protect you to allow you to get a patent in Europe? It's a complicated answer, but I'll first say NDAs are contracts, and lawyers would say contracts set up rights between the parties to the contract. So if you and I have a contract, I sign an NDA with you, and then you tell me your patentable invention, I publish it on the internet. You can sue me. You can sue me to say, Ed, you should not have published that because we had a contract. That does not change the fact that it has been published. The fact that it has been published could be used against you in Europe or elsewhere. Now, the law also provides that as long as it is a publication through the inventor, at least in North America, that often gives you a grace period. So you will have some protection in North America. You will probably not have much protection outside of North America, for instance, in Europe. Another question.
When you mentioned you said after publication of 1 year in North America, but you said by the inventor. So what I'm wondering is, let's say I publish something. someone else, within 2 months of that, goes for a patent for a similar product or something, does that mean that I still have to, because I published first, or how does that work?
So it's a first to file system in Canada. So the first person to file that application would be granted the ability to continue with the patent prosecution and potentially obtain a patent. The first one to file.
Fine, not the first
Right.
one to publish.
So the grace period that Ed is referring to is a 1-year period that you can file in, assuming no one else files. But after that 1-year period has expired, then you can't file at all because the novelty of your idea has already been extinguished.
Great. So I'm going back to my alternate universe where there was the original Death Star, built and tested, 77, I guess we'll call it, in A New Hope. A few years later, the Empire decides to build a second Death Star. And the Empire this time says, you know what, I've learned my lesson. We did our first Death Star, didn't apply for a patent, published it, now I can't get a patent. Now that we're building our second Death Star, I want to make sure I get a patent for my second Death Star. I apologize, the print's probably too small for anybody to read here, but the basic premise of this example is original Death Star has a diameter of 120 kilometers, whereas the new Death Star that they're planning has 160 kilometers in diameter. So bigger, better. And now the Empire says, you know what, before I test fire this, or have finished completion so everybody can see it, I am going to apply for a patent. We know it's useful. We knew the first one was very useful, so the second one's probably going to be useful too. Is it new and non-obvious to have bigger and better Death Star? I see somebody shaking your head. Why?
Because you already had the after publication of the first Death Star, so the second Death Star is not obvious anymore.
Perfect answer. The answer was that it has been publication of the first Death Star, so the second Death Star is not new or non-obvious anymore. Now, being lawyers by trade, we are trained to argue both sides of the case, and we can at least make convincing sounding arguments every time we have confronted a position. Yolan, what would you say if I said we want to make a case for the second Death Star?
So I would focus on the differences between the second Death Star and the first Death Star and try to find some sort of difference or inventive step that we've taken from the first version to the second version. And so if it could be anything from the triggering functionality or something that we've changed that we can really focus on, and we'd say a person who knows a lot about this type of technology would not have thought of that change on their own. They would have, this is something new that we've come up with.
Absolutely. And this is the concept of evergreening in the world of patents. You hear about this concept in the news. You have patent for version 1 of your technology, then you have version 2 you're releasing to the marketplace. You may or may not have secured rights for version 1. In a way, it doesn't matter. What the real question, as Yolan says, is, has there been a patentable advance between version 1 and version 2? Here you have Death Star version 1 and Death Star version 2, and before going to there, there's a question.
With the example that Yolan gave, where there's some new triggering mechanism, let's say, would you be able to patent the whole second Death Star or just that triggering mechanism?
So the question was, if there was a new triggering mechanism, would a new patent go to the whole Death Star or that triggering mechanism? I would suggest it's probably just the triggering mechanism. Innovations can come big and small. We jumped over a number of things when we were even talking about the first Death Star. There is the combination of the whole Death Star itself. That's what I would call a combination patent. It has a number of different features. It has turbo blasters. It has that big space beam, particle beam. It's got a trench tunnel. It's got a core. All those things together, that makes one new thing. Each of those things I mentioned could be its own invention. Triggering mechanism, the composite beam itself. What about, so I would suggest that the first answer that came was, is the second Death Star obvious in view of the first Star? I would suggest that's probably right on balance. Changing the size and dimension of something usually is not considered a non-obvious patentable advance.
If you own Death Star 1 patent and I made Death Star 2, would I be able to patent it?
So the question was, if I own Death Star 1 and somebody else came up with Death Star 2, can you own the patent to Death Star 2? The answer is yes, but What I haven't gone to is that patents are negative rights. They are exclusionary right instruments. What does that mean? The fact that you have a patent to the Death Star number 2 does not entitle you to build Death Star number 2. All a patent does is allow you to prevent anyone else from building Death Star number 2. What does that mean in respect of my Death Star 1? Well, if I hold the patent to Death Star 1, I can prohibit anybody else during the term of my patent from building Death Star 1. That means, yes, if you create a patentable advance in Death Star 2, you go ahead and patent it. But you still can't build Death Star 2, because Death Star 2 probably depends on the technology from Death Star 1. So in order for you to build Death Star 2, you still need to talk to me to get a license so you can build Death Star 2.
Yeah, and those are sometimes referred to as improvement patents. So if you have an improvement over an existing technology that's already patented, as Ed said, you'd likely have to get a license from the original patentee in order to use your improvement patent.
Yeah, so for version 2, if you don't have the patent, right, and you can just read up online about what the changes were, you can just tweak it a little bit, right? And all of a sudden
you have a new patent, right? So the question was, can't you just tweak it a little bit? Well, you have to tweak it enough so that it is non-obvious. So the courts, or I should say the patent offices, will enforce at least that much. You have to tweak it so that it is considered a new, non-obvious advance over what's been done before. So a tweak such as growing it by 40 kilometers in diameter would not be considered a tweak that's patentable, probably. But if you develop a new triggering mechanism, if you develop a new way to store the energy or to get the energy into a larger weapon than before, the energy that needed to be stored and released was lesser in the first star than the second star, and you came up with a new way of processing that, that is very likely a patentable advance. But to the gentleman's question over here, can you get a patent? Yes, but can you market that technology independently without talking to the owner of the first Death Star? Probably not. I'm going to flick through a number of slides very quickly now, just to tell you the limits of patentability. Not everything is patentable, even if they are new, non-obvious, and useful. Simple scientific theorems, or what we call abstract scientific theory, is not patentable. Math formulas are not patentable. Mental steps that are performed in sort of a person's brain without access to the physical world or equipment, not patentable. Higher life forms, not patentable. Methods of medical treatment, also not patentable. That does not mean medical devices are not patentable. It means the way of using technology to treat a human being, that's not patentable. These are examples set out by the laws. It differs from country to country a little bit, but generally speaking, in every country you encounter, there will be some limits to what you can and cannot patent, notwithstanding it might be new, non-obvious, and useful. So,
I was just going to ask about concepts. So can you patent concepts? So let's say your idea can be complex enough. It has multiple parts. And for each part of them, of course, you need to do the engineering work to build it. But as general, you're finding it can be basic combination of process and something else at the same time. But it's generic enough at that stage. How are you going to go for that? How are you going to patent that? Say, okay, I have this, now I'm going to fix the part inside of it, but this is the way we're going to fix this issue. Or there's a bunch of technology out there, you find a way of mixing them together to come with a new product, which is usually what happens in building something else.
So just adding aggregating different pieces of technology that already exist.
Completely different. It's not improving on what they were doing, but actually finding a way of making them work together. So someone is making a tire, someone makes a ring, but together they go on a car. You don't patent a car based on the tire.
So there can be ways to patent those sorts of systems that combine existing things. Again, the test comes down to whether or not it's inventive to combine those things, or whether it really is just an aggregation that is combining various components that the average person would have thought of. And so one of the things we didn't talk about is when you file your patent application, there's a lot of stuff that goes on behind the scenes in terms of establishing that your design is actually inventive. So there's a lot of back and forth that goes on with the patent office, and you need to provide arguments and establish a lot of evidence to show that there really is inventiveness and that the average person wouldn't have considered this before.
How do you draw the line between scientific principle and engineering methodology or patentable process.
So where's the line between scientific theorem and engineering? Well, first of all, it's no bright line test. I will admit that right off the top. How you would normally draw it is it an abstract expression of an idea, usually considered science theorem, or has it been applied to reach a practical solution, usually considered in the realm of engineering? The first is not patentable. The second is, what is a good example? Science formula E equals mc squared, not patentable, just a scientific fact. Application of that to an accelerometer to produce a result and apply it in a machine in the real world, I would say probably patentable, as long as it's new, non-obvious, and useful. And perhaps the limitation of scientific principle or theorem is that it is usually unapplied, as in, it's a generic theory. It doesn't necessarily have to be applied in any particular way. And it is the application of it, the utility, that gives it patentability.
Where's the borderline, or what's the difference between describing a process and it must not be a series of mental steps?
Excellent question.
So series of mental steps would be like an instruction guide or something that is giving someone instructions exactly how to do something. A process has more interworkings, so there can still be methods, which are a series of steps, but processes themselves tend to include an interaction of working components.
Yeah, absolutely.
I've heard, I don't know if it is an urban legend, but I heard that somebody patented X4 at some point.
At some point, somebody had the patent for X4, for exclusive for Sorry, I'm not sure I follow.
So for programming language, or
for a very simple logical, calculating a very simple logical basic.
Oh, I see.
So I would consider that to be an abstract principle that wouldn't be patentable. So I'm not aware of if that's true or not, but my gut reaction would be that would be an abstract theorem that you wouldn't be able to get a patent on. But
I'll also say this: patents are not perfect, in the sense that patents are granted ultimately by human beings. The entire process is human-driven. The law is the law. The law will say all kinds of things on a book. But you, as an applicant, will say, I have created an invention. You will come to a patent lawyer, and I will say, great, you have an invention. Let me write up a patent application for you. That gets sent off to a government office. The government is supposed to apply the law, but it's a human being that will read my application describing your invention. He or she will then say, do a search, see what the state of the prior art is. Is it new, non-obvious, inventive? Does it fit inside one of these categories? And make a judgment. You will have a chance to argue with this government examination person through your agent. Sometimes you win, sometimes you won't. There are clear, obvious cases, yes, but most of the time you're in a bit of gray. Depending on the mood of the examiner that day, you may or may not get a patent if you're very, very close to the line. And that's something to really keep in mind too when you're engaged in the patent process. It is not a perfect process. It is not perfectly binary. There are a lot of rules, yes. There are a lot of things to consider, yes. But it is not always black and white, which way any particular task will go. The question was, what does obvious mean? I will give you the legal answer, which is it obvious to a normal person of skill in the art who has encyclopedic knowledge of the entire state of the art, but is not a creative person? This person does not exist. It is a legal fiction, but it is the person to which obviousness is applied. And if that sounds entirely murky to you, it should. Very few courts actually know what something is obvious or not obvious. It's probably why you have lawyers usually trying to figure that out. There's one more question. I'm going to take that. I'm going to jump to the second case study just because I'm looking at the clock as well. Yes?
Can you file for a patent if you don't have a prototype yet?
The question was, can you file for a patent when you don't have a prototype yet? The answer is yes. You can file for a patent as soon as you have conception. So back in that napkin drawing that we saw earlier, as soon as you have that and you have a reasonable expectation that it will work, you can file for a patent application. The law would in fact say the act of creating those detailed plans is akin to creating a patent application, which allows you to to file for your patent application. Usually in that case, we'll do it so-called provisionally. And we'll leave the question of provisional versus regular patents to the question period. But generally, you would do it on a provisional basis. And then after a particular period of time, usually 1 year, you would come back with your prototype ready and prepare a full patent application. So with that, I am going to switch us over to the social network.
So by show of hands, how many people here have seen the movie The Social Network? Good, excellent movie. So for those of you that don't know, The Social Network is a movie about the founding of Facebook and the subsequent legal battles that ensued as the company started to gain success. So this fact pattern is really going to walk us through some of the pitfalls that occur when you don't properly define the questions pertaining to ownership, assignment of IP rights, and chain of title. So just to refresh you a bit on the facts, I'm going to walk through the fact scenario and then we'll discuss some of the considerations. So we have Mark Zuckerberg. He's a 19-year-old Harvard student working in his dorm room. He comes up with this idea for something called Face Match. And essentially he hacks into the Harvard servers and steals photos of a bunch of students, and then on his website asks other students to rate those students. So Harvard obviously is not impressed with this. They give him 6 months probation, academic probation. And I'll just clarify that all of this has to do with the facts of the movie, which may or may not all be true. So he gets academic probation, but what occurs is that he gets the attention of a couple other students at the school who are the Winklevoss twins. And so they see what he's been able to do with his Face Smash, and they're really impressed because they're working on their own startup company, which they call the Harvard Connection. And it's essentially an online dating site for students at Harvard. So they've got this idea for Harvard Connection. They see what Mark's been up to, and they reach out to him to see if he wants to help them with their project. So the key here is that they didn't really discuss or didn't write down anything pertaining to, the job requirements, how Mark was going to be compensated, who would own the IP rights to the company. So we don't really have any details as to how that was discussed, whether it was discussed. It certainly doesn't appear to be set out in writing at all. So Mark agrees to help with the Harvard Connection startup. But at the same time, he's really interested in his own project, which he's now called Facebook. So although he's supposed to be devoting a lot of time to the Harvard Connection project, he's really putting all his time and his skills to Facebook. That's his baby, that's his project. So he reaches out to his friend, Eduardo Saverin, and Eduardo's skills are really on the business development and marketing side of things. So he asks Eduardo if he wants to partner with him. Mark will do the software development, Eduardo will do the marketing side of things. So they agreed to be co-founders for Facebook. To sweeten the deal a bit, Eduardo puts in $1,000 of his own money in investment. So they've got this co-founding relationship for Facebook. And as we all know, Facebook really takes off. It starts to expand to other schools outside of Harvard. Eventually it grows even bigger than that, as we all know. Mark also gets a $500,000 angel investment from an angel investor. But the key to that investment is that Eduardo's shares, which at that point were worth 34%, were going to be diluted to less than 1%. So obviously, Eduardo is not happy with that. So what we end up with is Eduardo suing Mark for misappropriation, for losing all of the value of his shares. And then we also have the Winklevoss twins, who have seen what's happened with Facebook, and they say, wait a second, that's our idea. We told him about that. We met with him months ago. That was our project, and he's taken that, and look at the success that he has. So they sue him for IP infringement. So the question that we have really is, who owns all of the IP? So we have IP involved in the Facebook project. There's intellectual property, perhaps in the design of the website, the way that the website interconnects users. There are a lot of possibilities, a lot of technology that's been put into that. Possibly some of it would be patentable. There would be potentially trademarks in the Facebook name, but who really owns all of that IP? Does anyone have any ideas based on all these facts? I mean, we don't know. Nothing's been set out in writing, so it's really just one person's word against the other, right? So we've got Mark who says, that he came up with the idea of Facebook, a long time ago with the Space Mash, that he's put all of his time and effort into it. We've got our Eduardo that probably says he has rights to some of the trademark and the design materials involved in it. And then we've got the Winklevoss twins who are going to say, wait a second, we met with Mark months ago and we told him about that idea and he stole it. So what could the parties have done to help avoid some of these uncertainties and maybe reduce the risk of all of the lawsuits occurring here? Yes?
The Winklevoss twins could have gotten an NDA?
Exactly. So that would be my first suggestion, would have been as soon as they met with Mark to have a simple NDA drafted. So an NDA or a non-disclosure agreement is another word for a confidentiality agreement. So this is really a basic 1 or 2 page agreement that you put in place. Yeah.
From a social perspective, how do you approach somebody like your friend and say, hey, I have something to share for a project, sign this NDA? How would you actually go about doing that?
That's a very good point. So it can be a bit awkward to bring that up in a first meeting. So his question was, how do you approach it in a social setting? So that's a good question. A lot of times you're meeting with colleagues, you're meeting with friends, but I would just approach it from a practical point of view, saying, this project means a lot to me. I really care about it. I really think I have a good idea here, and I'm just trying to protect myself. Mention the Social Network movie. You're like, remember what happened in that movie, The Social Network? So yeah, it can be a difficult question, but I would just approach it that way. Yes?
There's so many websites nowadays. Like there's Elance, now there's Fiverr. There's more, and you're oftentimes, giving your ideas out to those people so that they can design your video advertisements, social media, even designing your website. So how do you ensure, like, if you don't have a patent, you're asking someone for help? Because they don't have any sort of NDA agreements on their website that they can enforce.
Yeah, so it can be a bit difficult when you're working with these companies that already exist because they're a big power and you're, an individual. So it really is an imbalance of power. So it's a bit of a give and take. Like, I would suggest always reading the terms of use on those websites. They're always going to be favorable to those companies, but at least you're going in with your eyes open in terms of what you can and can't do. And maybe you'll read them and say, you know what, there's no way I want to work with this company. I've looked at the terms of use of another company and I think they're more favorable or they fit better with what I'm trying to do. Yes?
So in this case, because it was, you can say it was hearsay. They were talking, so there was nothing in writing or something. Even if you don't have an NDA, but let's say, for example, you email a request, you say, hey, this is my idea, blah, 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 can you help me with it? Or this is what I'm doing, which is what you were mentioning about between the concept and then working on it. Or you ask someone for their feedback on it. And this happens especially, like, say, in academia, where we do this all the time. At that point, because at least there is some track of what you have done, do you have any protection? Or you
have a certain degree of protection. So his question was, is there any value in the email communications and the correspondence that goes back and forth, irrespective of there being an NDA or not? So this is all valuable evidence to have on hand. If you're working on a project and you have design notebooks that are dated, all of that information would help a court of law assess, where the inventive concept came from, who it was that created it, what the timing was. So it helps to piece it all together. But the simple answer is NDA makes it cleaner. So you have a clear action against that person for a breach of contract if if you set out your idea. So typically an NDA will set out what information the parties are bringing to the discussion and then prevent one party from disclosing that information or using it for their own benefit. So the NDA really helps to clarify things and it gives you a clear breach of action. So you could, go to a court of law sooner or even just scare them with the document, right? So
the reason I asked it, and you probably noticed, Waterloo is one of the very few universities who actually own the patent. So you have the right to your own application, to everything else. And let's say in my case, I'm working with my supervisor, I have something and I have to discuss it. I'm asking for it, that's their job to help me stay on the scientific part of things. But at the end of the day, when it comes to publishing it, would that be my work or would it be their work? Because you send an email to them, you ask a question, and
and we have a slide on the ownership policy here at UW in terms of IP, so maybe we'll leave that question to that slide. I think it would be better addressed then. I'll take one more question and then I'll move on. Yeah.
What happens if you sign an NDA and the person you signed it with either like the company disappears or they die or something happens where that party disappears.
So his question is, what happens if you sign an NDA with a party and then that party disappears? So I guess the risk there is that you're saying they've disappeared, but they've also taken all your information and potentially disclosed it. Is that the concern?
Let's say I'm Mark, and I signed an NDA with the W twins.
Okay.
And those W twins, they disappear, like whatever happens.
I mean, the risk there is that they haven't really disappeared. So depending what the NDA says, typically an NDA will have a time period associated with the confidentiality obligation. So if there's a time period of 5 years and that's lapsed already, then you have some comfort that, that your obligations under that confidentiality agreement no longer exist. But otherwise, if there hasn't been a clear termination of the agreement, then there would be risk with disclosing that information, with the potential that the person still is out there and just is off your radar for the moment. Okay, so the first step that the Winklevoss twins should have done was sign an NDA. The next step that I wanted to talk about is employment agreements. So after they met with Mark and they discussed, they brought up their idea and they came to some sort of agreement as to what Mark would be doing on the project, the next thing that we would recommend would be a simple employment agreement. So not only does an employment agreement set out terms like compensation and job expectations, but for a tech startup, a really important component of that employment agreement is IP provisions, so IP ownership. So typically, the terms that we'll see in this type of agreement will be, any work that the employee does in the course of his job activities, or in the course of his job, will be owned by the company. If it's work that he does on his own time with his own resources, then typically we see that being excluded. So the question here would be, when Mark was creating Facebook, was that really his own project that he was doing on his own? And so anything that he invented during that time would be owned by him. We don't even have an employment agreement, so it's not a real consideration in this case scenario, but those are the types of things that you want to think about with employment agreements. And the third step that we would have suggested would have been for the Winklevoss twins to file some sort of IP registration. So if they really did have an inventive idea in those early stages, something to do with the inventive concepts of Facebook, then they could have considered some sort of patent application. So typically, as Ed said, for startup companies, a first step is often a provisional patent application, and this gives you a 1-year period to protect your idea, decide whether or not you want to file a full patent application. And so it's a really, relatively cheap step that you can take. If the Winklevoss twins had done that early on and had actually, referenced and mentioned some of the inventive concepts of Facebook, then they could potentially be a lot richer if they had converted that into a full patent application. Yes.
How could Mark get into the deal without Eduardo's approval? They had 50-50 on Facebook, right?
Yeah, I don't know. I don't actually know the details of you're talking about he's saying how could Mark have entered into the deal with the angel investor when Eduardo also owned shares in the company. I don't know how their share structure was at that point. So sometimes there'll be voting shares and non-voting shares. So you could assign shares that have different powers, essentially. And so I imagine it was something to that effect.
So just as a journalist, I am out of just because we asked that question. Is it possible once you get into an agreement, let's say you decide to work with someone and you agree on the percentage, whether it's on the patent or on the workability, feasibility, whatever it is, can one person, without, because you already have a contract, without your knowledge change that? In this case, I know it went to court, I know this happened, but in general, how is it possible when you have an agreement with someone else who decides to dilute your shares or your percentage of ownership?
Mm-hmm. Yeah, again, it depends what share structure they had agreed on. So they did have some sort of agreement in place because they were issuing shares for the company at that point. But I don't know the details of.
So it's legally possible. I just want to know if it's possible, or is this something that generally should have not happened and that's why you're in the court, or is it something that can actually happen? Is there a way when you're getting into a contract with someone to do that to you? From our protection, going to an investor, they might put us there and say, well, yeah, sure, you can have 30%, and then have 70%, but later on you find out only 1% of it. That's
I'm going to jump in a little bit and try to take this one. So the question was, is this legal? Can somebody jump in and dilute your shares down, steal your shares? The answer to that is no if you have good lawyers. So talk to Cheryl, talk to David. What the situation likely that arose here with Facebook is likely that there was a share structure and a shareholder agreement in place that probably permitted some form of dilution of the founding members' shares. Perhaps not as extreme as 34% down to 0.3%, but there probably was a mechanism that was agreed to. Now, this is all possible to be agreed to between the founders or between the shareholders of a company. It's the concept of a shareholder agreement that Cheryl spoke about 2 weeks ago. That can be put into place when you start your startup company. And those are the rules to which decisions about the company can be made. Those are the rules pursuant to which you can bring in another investor. The initial investment was $1,000 for Eduardo. Not an insignificant sum of money for a student, obviously, but you're now bringing in $500,000. That's a real investment. It's something that your company probably wants. The real question from this fact pattern was, and your question was, how is it fair that only Eduardo's shares got diluted? Why didn't Mark's shares also get diluted down to 0.6%? Those are the rules to which your shareholder agreements ought to address. Those are the rules that your corporate structure should address. And that's why we have a two-part series. This is the second part series on IP, the first series on corporate structures, corporate shareholder agreements, employment agreements. Those all matter. I'm going to lob a question at Yolande. This whole movie is about the startup, Facebook. Is there a second startup here, and are there lessons learned for that?
Yeah, so the other startup would arguably be the Harvard connection. So unless you're referring to another one. But
no,
so all the steps that I've referred to already in terms of the NDA, the employment agreement, registering their IP, those are really important steps that the Harvard connection could have taken. They could have potentially incorporated if they didn't. So all of those steps would have helped to protect their legal rights and would have potentially stopped Mark from going off and doing his own thing and taking potentially IP with him.
So, let's go back one more. I want to do one. I'm going to jump in if I may. So, there was the Harvard Connection startup. I want to just pause there for a second for a lessons learned, which is there were two startups here. There was the Facebook, there was the Harvard Connection. One thrived, and frankly, what happened at Harvard Connection? It died. It died an ignominious death. Now, we don't know the facts. This is a movie. It is not even a documentary. It is a docudrama. Half the stuff in it is made up. We're using it because it's just, a more dramatic fact pattern. But if you trust the movie's chronological presentation of facts, arguably, Winklevoss brothers came up with the Facebook. Arguably. I'm not saying that's true. I'm saying arguably on the facts of the movie. They had the idea that is now billions of dollars. If you saw the movie, you would have seen they won a very substantial cash settlement from Mark and the Facebook team as well. Great. Millions of dollars is good. But had they done what Yolande suggested, had they actually put in proper shareholder agreements, had they actually properly brought in Mark as an employee, or at least had the discussion, Mark, we think this Harvard Connection dating site is our idea. We know you did Face Mash. That's yours. Here's our line. You're going to pool your IP into our company. We're going to share with you some shares in our company, or we'll pay your salary, whatever it is. Had they even just had that discussion, it could be today, it could be the Harvard Connection rather than Facebook you have all in your smartphone apps. Could be. Who knows? So Harvard Connection, Winklevoss brothers, yes, they were successful in the end, lots of money in their pockets, but would they have been happier had they done all the things Yolande did? Created some proper IP, proper NDAs, proper assignments, so that they could take their own startup to the next level rather than, frankly, letting their own startup die. There's a question back there.
How can the Winklevoss twins claim IP when their idea was a Harvard dating website and Mark created a social network that had nothing to do with Harvard or dating? How can they claim IP on that? And he didn't use any of the original source code from the Winklevoss. So, how is that their intellectual property when the idea that Mark created has nothing to do with the idea that they pitched to Mark?
Well, I think part of the issue is, so his question was how could the Winklevoss twins claim IP rights when from the movie, we see that they had a dating site. We know Facebook is more than that. It's more of a social network. It has more layers to it. So really the question is, we don't know what went on behind the scenes in terms of the discussions that they had. Were they sitting in a room and did they brainstorm these ideas together? Likely they may perhaps have made an argument to that effect, right? So we don't know where the line was drawn, as I said before, between when Facebook was clearly conceived and whether it was conceived earlier on.
Okay, so for you to claim intellectual property, do you have to personally pitch ideas towards, like if it's software, towards the software, like so they had to brainstorm something that was put on Facebook for them to
So if they were joint owners, if we take the argument that they had a brainstorming session and they came up with the idea together, they would have all needed to have contributed to whatever it is that was inventive about Facebook. So, this is all along the arguments that Facebook is even patentable, that there's aspects of it that are patentable, right? Assuming that's the case, then they would have had to have all worked together to create that to be joint owners.
We've already been told that lawyers don't sign NDAs. How can we protect ourselves when we're going to talk to a lawyer about it?
So we are legally obligated. So it's part of our, we're part of the Law Society of Ontario, and it's our professional duty to maintain the confidentiality of our clients. So even if we speak to you within a relationship of potentially taking you on as a client, and you talk to us about your idea, and it ends up that we don't end up being your lawyer that you hire, we still have an obligation because you're a prospective client at that point. So if we were to go and take your idea and steal it, we would be disbarred and all sorts of bad things would happen. So, hopefully that gives you reassurance on that front.
But you could be disbarred because you have Facebook.
Fair point. Completely a fair point. We have a few more minutes before we jump to questions. Why don't we take the next one as well? So the kernel, which I suggested we would talk about if time permits, this is a fast one and a quick one. But I did want to say that we might be remiss if we didn't even ask you this question, which is, if you came up with the idea of a new food chain restaurant of a special recipe for frying chicken, do you think you should get patents?
No.
Can you patent the way you cook the chicken? Or?
Yeah, you might be able to. Hand up, I'll go with that.
I'd probably try and keep it a trade secret if possible. Yes.
So he's a trade secret if possible, and I think that's probably not, there's no black and white to this. Probably the answer is you would want to keep a trade secret, and look, given the picture I've posted, there's a big hint there as well. The KFC recipe is not patented, nor is the Coca-Cola recipe. These are things that have been kept as trade secrets. Arguably, when they were first developed, you could have gotten patents. I'm not 100% sure.
People ask the question, can you patent a food recipe? And it's an extremely high bar to meet because essentially you're just mixing existing ingredients together. So the obviousness issue that we've been talking about would come up. So
yeah, but in a business like this, what is distinctive? I mean, you can say the distinctive taste in the chicken, but given KFC's global growth these days, I can assure you it's not the secret recipe itself. Recipes have been localized for different jurisdictions. I would argue it's the brand. It's the association consumers have with KFC. You think about, well, even Facebook. You think about Facebook itself didn't have a ton of patents until after its IPO. It built most of its market equity through branding, as your line says. It's the Facebook logo, the drawing of the kernel, a market awareness, a market share, which really drove the value of those companies. So this slide really is to tell you that patents are not the be-all and end-all. Patents are great. Patents are wonderful for technologies, but you don't always have to have them. Sometimes just having good business agreements, good business structures, good employee agreements are just as important, if not more important, depending on the startup business that you're in.
Wondering, wouldn't you have to issue trademarks?
Yeah, so the KFC logo here, so the kernel and the KFC name, those are all trademarks. So you couldn't just open up a fried chicken store in Waterloo and call it KFC, or they'd come after you for trademark infringement. So why don't we go to the slide on the University of Waterloo's policy on IP ownership. So this is really important for you guys. your students at the school, perhaps some of you are professors. So a lot of the work that you're working on and the ideas that you're coming up with have some sort of nexus to the school, whether it's your fourth year design project, or if you're a professor, if it's the coursework, the course materials that you're preparing. So the question is, do you own those IP, the IP that you create that has a nexus to Waterloo, or does the university own it? So each university has their own policy. I would say Waterloo's is a very favorable policy. So if we take a look at it, here what it says is that the creator of the work owns the IP in it, with a few exceptions. So the first exception being if it's a university assigned task. So perhaps if it's
your job and your job description.
So if it's a professor that's been asked to prepare course materials for ECE 101, arguably those materials are owned by the school. So that doesn't mean that there isn't a way that we can transfer ownership. So there could be an assignment or some sort of additional document that could be used to counterbalance the status quo. But this is the basic position, and if you want to change that, then you need some sort of other legal document. So that's the first exception. The other one is sponsored or contracted research. So if you are being sponsored by the university to conduct particular research, typically you'll have a sponsorship agreement or some sort of contract in place with the university. So you'll want to look to that to see what it says about ownership. And then the last bullet, or the last exclusion, is that the university will claim a non-exclusive license to use your technology or your invention. So that's sort of a carve out to whatever IP right you have. So if you own the patent to a particular technology, there's a carve out to that that lets the university use that technology.
And, please, question.
Just, yes, on the sponsor and contract research. So for example, if we start, usually in my case, I'm a PhD student. So I'm halfway through my research, and at this point, we might have sponsors coming from outside. Mm-hmm. My research result, that's where they trade. So would I use that right if I do not patent beforehand? Because at this point, the university is trying to get funding for it, so they would like to take that project to the next level. What will happen? Because the invention, the concept that comes from me, which has happened before this is not, my regular funding as a student. What will be the legal basis?
So I guess his question is, what will be the legal basis when your sponsorship ends, or
when the sponsorship starts?
When the sponsorship starts.
I already done the work before this.
Okay.
So let's say the patentable idea is coming before this, before any sponsorship was required. But in order to continue my studies, I need to work for them. Which at that point, then they can say, oh yeah, I can claim whatever work you're doing. So that's why I'm asking.
And do you know if you're going to be entering into a sponsorship agreement?
I think so.
So what you would do is look at the language and the text in that to see what it says about IP ownership. And obviously, if you want to negotiate that, there's a potential to negotiate that as well.
Yeah, and there usually is. And I'm looking at the clock, and we're slowly running out of time, but I'll come to the question too. I just want to point out, in Waterloo, you have a lot of resources available to you. For those of you who don't know, you have your own commercialization office. It's called Watco. We put up a link to their website there. Certainly a chance for you to explore ideas around your IP. Should I get a patent? Should I file provisional? Should I think about a sponsorship agreement? What should I put in my sponsorship agreement? Should I accept that the sponsor will be the owner and I have no rights, or should I push for some rights for myself or the university? Definitely a first stop for some resources. And of course, there are, legal resources you can reach out to as well. There was one question here. We'll take that one. Then we'll break into groups and continue to take questions.
Okay, so you mentioned university assigned tasks as exceptions. For your fourth year design project, is that considered assigned by the university because you have to do it in order to graduate, but they're not telling us what idea to make?
Yeah. So the question was, is your fourth year project a part of a university assigned task? I don't believe so. I actually don't have the good answer on that. University assigned task, I believe under your policy means if you're an employee and the university says, hey, go build X, then that's an assigned task, whereas your school project is often considered not an assigned task. It's your own work. But I would suggest call Watco and have a quick chat. But that's my guess on that front. So on that, Yolanda and I are going to end sort of our podium presentation, if you will. Why don't we split this up into two groups? So I'm counting out. I'm going to say the first 4 rows. Why don't you continue to face forward, and we'll take questions here. I have colleagues in the back, so I'm saying from the 1, 2, 3, 4, from the 5th row onwards, ask your questions to my colleagues sitting in the middle. There's a name tag. They will answer that too. Group around them if you want, crowd them if you want. If you want to move forward, please do. But we'll continue to pick questions and then well, let you out and get some dessert and coffee. So to everybody on the web stream, thank you for watching. It's been a pleasure. And again, a thanks to the University of Waterloo and the engineering department for having us tonight. Thank you all.